Once again, a very warm welcome on this online learning portal of Drishti IAS. And in today's segment, we are going to talk about the discussion on the recently held paper for the mains, and that is the polity component. So today's topic would be focused upon this paper discussion, and the subject we'll be covering today is nothing but the Indian polity. So here, my name is Ravi Pathak, and I'll be taking on with the discussions of a couple of questions which were asked in the recently conducted examination. So let's begin now, and before proceeding, we can see the year-wise pattern or year-wise trend of the questions which had been asked, and you can see almost every year you can see 100 plus marks questions or worth questions are asked, except the last year. So last year थोड़ा COVID का भी issue था, political developments काफी कम थे, but this year you can see again there is a steep rise, and roughly about 115 marks questions worth had been asked from Indian polity. When we see or take up the nature of the questions asked, then probably you can see that couple of topics which are frequently being asked in UPSC Civil Services Mains examination. There we have highlighted, so you can go through this also, that basically from the Indian Constitution, the features and the provision part, there we have a good amount of questions asked from last 5 years. You can see very carefully. And then probably some questions from the federal structure and the local government. Apart from that, the core areas like legislature, executive, judiciary, these were also covered, right? And probably after that, some miscellaneous topics which may be having overlapping with the governance issue also, and the separation of power SOP or the constitutional terms and the bodies, or the constitutional, extra-constitutional or judicial or quasi-judicial or extra-constitutional judicial devices or the bodies could be there from which we can expect certain questions. So this analysis would definitely help you to get an idea that what are the areas which needs to be focused. Now when we talk about the questions asked this year particularly, then there you can see, you can keep it at a difficulty level from the simple to moderate to difficult. Then this year questions were also more or less moderate in nature only. And the one thing which we have to take a note of it is nothing but these questions can be answered very easily because, or suppose if you have the very good and thorough basic understanding of the subject. There was some tone in which you can relate it with the current developments also. Some of the topics were there from the recent coverage, or we can say that political news which were there in last 6 to 1.5 years or so. But even those questions can be answered if you have a thorough understanding of the basic aspects, or we can say the core part of the Indian polity. So let's move on and take the couple of questions which were asked in the previous year. We'll start with the first one, and here you can see the question is, the most significant achievement of the modern law in India is constitutionalization of environmental problems. So here we can see, we can highlight some of the keywords which will help us. The most significant achievement, and basically in terms of law in India is nothing but the constitutionalization of environmental problems, especially by the body that is Supreme Court. So here we know what is the role as far as the Supreme Court is concerned in our constitutional scheme. So we can see that what is the role, or especially we can understand from this particular circle, legislature, judiciary and executive. So basically the legislature is the one which have the role in lawmaking. Executive is the one which have a primary role of law implementation. Though we don't follow the strict SOP, we follow the weak separation of power. That's why we can say there is a degree of overlapping also, but to avoid any sort of encroachment, we do follow a doctrine of checks and balances as well. However, judiciary's role is nothing but interpretation of whatever the laws which are made by the legislature or implemented by the judiciary. So again, we can say this is nothing but the question which is popping up from part 5 of Indian Constitution, that is Union Executive, Legislature and Judiciary. So if you have done the thorough study, definitely this would be a direct question which you have got. And then secondly, if you see, discuss this particular statement what has been given in the courts with the help of some case laws, or especially the relevant case laws which were there, and this question is supposed to be answered in 150 words. So since word limit is short, we do not have much scope and the probability to include so many points because so many case laws and all those things are there. We have to be very precise and accurate as far as hitting the demand of the question is concerned. Since the keyword is discuss, so we have to discuss. That means here we get enough opportunity to include and explore both the sides, that is positive aspects also and some of the critical or the negative aspects also related with, we can say, the achievements as far as the modern laws vis-a-vis environmental legislations are concerned. So that is what the whole idea, or we can say the demand of the question, which we need to take into consideration. So here, as far as the structure of the answer is concerned, definitely what we have to keep it in mind that when we write the answer, so discuss, so simple keyword, we can start our answer with the opening statement and then followed by the main body of the answer, which we generally do, and then followed by the closing statement. So here the opening statement and the closing statement is important, and the main focus would be on main body of the answer. That is nothing but what they are trying to ask is nothing but with the help of relevant case laws related with the environmental problems which Supreme Court has given certain verdicts related with that. So here when we talk about the significant achievement of the modern law in India as far as constitutionalization of environmental laws are concerned, then we have to take into perspective, because as far as the environmental legislations are concerned or environmental laws are concerned, then directly we do not have any reference as far as these laws are concerned, because if you see the constitution making, or we can say the beginning of the constitution from 1950s and till today 2022, then here we can see that in mid 70s or early 80s, the awareness or proactiveness related with the environment and ecology had been of prime focus. So probably we can say up to 70s there were no much bigger legislations, as we can see, was there as far as the environmental aspects are concerned, maybe because of the not so polluting environments were there, or lack of awareness was there, or not it was significant as it is today. So there not much developments were there, and if you understand this background, then you'll be able to start your answer. But in the 70s, if you see, then the most important legislation we can quote is nothing but 42nd Amendment Act 1976, where certain environmental legislations and proactive steps were taken up by our legislature and executive. So here we can see that as far as the environmental concerns are concerned, then they were basically dealt in Part 4 and Part 4A of the Constitution. Part 4 is related with the DPSP, Part 4A with the fundamental duties. So here we can say, especially the Article 48, or to be specific 48A, which has been inserted in this particular amendment, talks about the protection of the environment, and here also Article 51A, right, that deals with one of the duties as far as the protection and maintaining the harmony with the environment is concerned. So if you have a very clear idea about it, or if you were in a position to recall at that point of time, then probably you can start your opening statement by just giving the background here that in 70s the legislations were started getting incorporated into so-called our constitution, or constitutionalization of the environmental laws began. But prior to that, actually the background was especially the phase of 70s, where not only at the national level but also at the global level, the proactive steps towards environment were started being taken up. So there you might refer, or even if when we talk about the protection of the environment, or we can say the legislation like Project Tiger and all those things have started, and then various conventions, COPs, and then CBDs were started, and finally coming to 90s we have started with the Earth Summit and all those things. But definitely that part is not supposed to be mentioned here, but yeah, 3-4 lines you can definitely take up as far as your opening statement is concerned. Now, when we talk about the role of Supreme Court as far as this constitutionalization of environmental laws are concerned, then here we can in brief mention about some of the case studies, because that's the main demand the question is trying to address. So here we can start with some of the important legislation, and we can start with the case known as Menka Gandhi case, right? So when we talk about Menka Gandhi case, basically this case is not directly related with the environmental legislation. We all know that, and we had studied that also. And though this article which related with it is nothing but Article 21, which talks about right to life. And when we talk about right to life, obviously we know there is a wide interpretation of the term right to life was done as far as the Menka Gandhi case is concerned, because before that we had the A.K. Gopalan case of 1950s or 51, where the narrow interpretation of right to life was done, wherein right to life was somewhat like, an animal existence. But when we talk about the right to life interpretation in Menka Gandhi case, then here the term which was actually emphasized was nothing but the right to life with dignity. Dignity was the word, or we can say this was the wider interpretation of right to life. And later on, many cases were there in which the ambit of right to life had been enhanced drastically, and it was considered to be one of the widest amplitude having in the Constitution, that is Article 21. So when dignity came into existence, there we can say right to life had started including the right to clean and green environment, also the fresh air or pollution free air or safe drinking water, etc. also became the part of ambit of right to life. So here we can say right to have a clean and green environment is also a part of right to life, or we would say right to life with dignity. So that's how you can relate the beginning, or we can say constitutionalization of the environmental laws, by mentioning these two important cases. Then after that you can also include the another case which is very important, related with some important legislation in the MC Mehta case. So first you can mention about the Menka Gandhi case, and then after that MC Mehta case. MC Mehta case we had studied in other aspects also, especially the child labor or hazardous environment and all those things. But here in MC Mehta, we know that, probably being one of the eminent environmentalists, he had filed multiple petitions in the court of law, and there Supreme Court came with the verdict giving in favor of the constitutionalization of those environmental laws. So MC Mehta, Indra Menka Gandhi case and A.K. Gopalan case, these are a couple of the cases which you can mention as far as the constitutionalization of environmental laws are concerned. So when we see this particular question, here the basic question is nothing but you have to discuss about the statement with the help of relevant case law. Since the question is for a very short word limit, that's why we may not get a lot of opportunities as far as mentioning a couple of more cases are concerned. However, the significance of the modern law in constitutionalization of environmental problems by Supreme Court can be highlighted, right? Or you can say, you can take a pro stand that yes, the Supreme Court of India had played a very proactive role as far as constitutionalization of these environmental problems are concerned, through different case laws, through different interpretation, or we can say by using various doctrines propounded by the Supreme Court from time to time. So like that, you can cover up the answer as far as this particular question is concerned. All right. Now let's move on to the next one. So when we talk about the next question, then it is nothing but one of the direct question again, which had been asked from the part 3, and always we emphasize that part 3 and part 4 is important for polity always. And here we can see the question is asking for right of movement and resistance. So when we say precedence and movement throughout the territory of India, are freely available to the Indian citizens, but those rights are not absolute in nature. So very direct question, no twist at all in this particular question. And if you have the clear-cut understanding of the part 3 of the Constitution of Fundamental Rights in per se, then you can answer this question very easily. This question is for comment and the answer has to be written in 150 words. That means here also the word limit is very short. We have to include all the points within the ambit of 150 words. And secondly, the comment part is given. That means we have to focus on the critical areas, or we can say the negative aspect of it, or the reasonable restrictions what we have. So here when we talk about this particular part, then as far as the question is for the comment, obviously it will have both the things. That is nothing but we have to go with the intro part, then obviously we'll cover the main body, and after that, rather than closing statement, we have to conclude. That is, we have to write the conclusion also. Now if you see this right of movement and residence, then probably I hope we all have the idea that from where this particular right had been started. So here we can say this question is directly from part 3 of the Constitution, and when we say part 3 titled as fundamental rights, we know that this have multiple or manifold classification: C1, C2, 3, 4, 5, 6 and 7. So here when we say C1 like right to equality, then we have C2, second fold classification, which talks about a right to freedom. So this question is basically related with right to freedom, which is a cluster of articles. 5 articles are there, starting from article 19, then we have 20, then we have 21, 21A and 22. So this particular question had been picked from article 19. Now we all know that article 19 again have 7-fold classification, which includes the right to freedom of speech and expression. And the clauses which we have in 19 is 19 clause 1 subclause A. So like that we have B, C, D, E, F and G. And if we talk about the present question emanates from article D, 19.1 means 19 clause 1 subclause D and E, where D and E talks about the freedom of and the freedom of residence. So these two parts are included in 19.1D and 19.1E, we can say from here. However, if you have studied the article 19, then you might be knowing there are other clauses also: 19.2, 3, 4, 5 and 6. So there are 6 subclauses in article 19. Now the 6 subclauses are nothing but these are the reasonable restrictions what we have on the freedom which is provided under article 19. What is reasonable restriction and all that we have done. And we know that fundamental rights are not absolute in nature. That's why they are subjected to certain reasonable restrictions. So since they are not absolute in nature, that's why they are subjected to some reasonable restrictions. And these reasonable restrictions of article 19 are mentioned in 19 clause 2, 3, 4, 5 and 6. So 19 clause 2 is nothing but restriction on 19.1A, 3 is on 1B, 4 is on 1C, 5 is jointly on both, that is D and E, and 6 is on G. F was right to property, which had been repealed in 44th Amendment Act 1978 and moved to a legal right or a constitutional right, that is in article 300A. So here we can say the reasonable restrictions are there, which are mentioned in article 19 clause 5. That means constitutionally also, if you look at the question, then here it ascertains the statement that these rights are not absolute and there are certain reasonable restrictions which are applicable on the right to freedom of movement and right to freedom of residence. However, what are those things that we have to mention? So like that you can start your intro by giving that from exactly where we have got the question. Then if we see the main body content, then here we can start with article 19.1 and the clauses or subclauses D and E. So when we talk about D and E, give a passing reference to 1D as a movement. Please remember, here we are talking about the movement which is internal in nature. When we say internal, that means let's say India. So in India, we have a right to move from one state to other state, right? And we also have a right to move within intrastate as well. That is within the state from one district to another district. This right is given to us, but it is not related with the external movement. Suppose we want to go out of India, then that right is ensured in Article 21. That is right to life. So right to freedom of movement within the country is what 19(1)(d) talks about. Though the question does not mention exactly that whether it's a freedom of movement within the country or outside the country, but we believe that it is for the within the country only, because movement and residence both are given together. So here we can say we do have a right to move within the country. And why we have? Because we enjoy the domicile at the state's level, and when we talk about the country level, then being a citizen, since we have a single citizenship for the whole country, to promote unity, to promote integrity, to promote fraternity, the freedom of movement is allowed without any hassles or without any obstructions. Similarly, when we talk about residence, now residence means what? It could be a temporary residence at a place, and if somebody wants to become a permanent residence of that particular place. So the moment somebody wants to become the permanent, then that would be nothing but getting the domicile. That right is also there. I may be from Delhi, or I may be working in Delhi. So suppose I am from Delhi, my domicile is from Delhi or MP or Rajasthan or Karnataka, anywhere. But I have a freedom to reside at any other place also for my work, for my education and all those purposes. But the moment I decide to become a permanent resident of that particular state, then I may have to go for or opt for domicility part. That freedom is also allowed. So this is related with the residence part, and this is related with the movement part. So residence here means we are talking about the permanent one. That is, I must have the right to reside or settle there, or I should get the domicile of that particular state or the union territory in which I am planning to stay permanently. So that is a one thing. However, as told earlier, that this is not absolute in nature. Since this is not absolute in nature, that means we do have certain reasonable restrictions which are imposed on these rights and which are mentioned in 19(5). So you can give some examples that this freedom of movement and residence can be restricted, maybe by imposing certain restrictions. Like, for example, you can give the recent COVID example, that in the times of COVID, because of the, you might have heard about quarantine, you might have heard about social distancing and all those things. So quarantine was one of the example wherein we can say the freedom of movement was restricted, or we can say on the health ground it can be restricted. Then probably the right to freedom of movement and residence can be restricted on the grounds of health, means public health, or suppose somebody is suffering from communicable diseases, right? Or we can say somebody is into a business of prostitution, or there is a probability of transmission of sexually transmitted diseases and all those things. So even their freedom or the residence may be restricted. Plus, there is a protection given to some of the tribes. So basically we can say the scheduled areas, especially the schedule 5th and the 6th schedule of the constitution, which talks about the scheduled areas and the tribal areas, even the freedom of movement or residence can be restricted there as well, to protect and promote the primitive nature or the culture of that particular tribe or tribal areas. Then you could mention some of the restrictions like inner line permit or protected area permit, which is there. Some of the states and their some part of the territories are included in inner line permit areas also. So that could also be one of the reasonable restrictions which can be imposed on freedom of residence as well as the freedom of movement. So pretty simple answer. And as far as the conclusion part is concerned, so definitely these restrictions are justified, because the parliament had the power to impose these kind of reasonable restrictions. Executive is going to implement those restrictions, but if it is coming in contradiction with or violation of any of the other rights or fundamental rights, then whether these restrictions are the reasonable ones or not, that would be definitely decided by the judiciary. So that's how you can close your argument. Then let's move on to the Next question, which was there this time, most of the questions we have got direct only, so it was easy to answer as well. Now here the question is about discuss. So again the keyword is discuss, simple keyword. Role of the Vice President of India as the Chairman of Rajya Sabha. So already we know how to handle the keyword called discuss, and a straightforward question again from part 5 only. And when we talk about here, then the question is asking about the role of the Vice President. So here you can start with a brief opening statement that who is the Vice President, or we can say how the Vice President is elected, or what is the role and responsibility. But better would be directly hit the question, because the demand of the question is discuss the role of Vice President of India as the Chairman of Rajya Sabha, right? So we all know that when we talk about the Vice President, then basically Vice President's role comprises of two main function or twin function, we can say. The one here, the Vice President act as President of India. So that is the one role which is given to the Vice President of India in case of a vacancy, or in certain circumstances when the office of the President is vacant or President is unable to discharge the duties. So when Vice President acts as a President of India, then he or she gets all the powers enjoyed by the President of India, all the privileges like emoluments or the salaries and allowances, etc. would be entitled to Vice President also, because at that time he or she is working in the capacity of the President of India. So that's the one core function or main function we can say we have for the Vice President, because we know that as far as the Vice President and President is concerned, here the President office is a continuous office. There cannot be an interregnum or a gap between it. So it's a gap, sort of gap filling arrangement what our constitution makers have provided. However, the second important aspect is nothing but to act as the chairman or the chairperson of the Rajya Sabha. So on this we have to have the points which we can include in our answers. So when we talk about this particular thing, a small brief about his role can be given as far as the chairperson or chairman of Rajya Sabha is concerned. So when we see our arrangement, the parliamentary form of government, we know that our parliament comprises of two houses. One is the Lok Sabha, other is the Rajya Sabha. Lok Sabha, it is nothing but the house of people, we can say, or the popular house, but Rajya Sabha is the one which represents the Council of States. So since we follow the federal nature of our polity, and because of the federal nature of Indian polity, what we can say that we have an authority that is called President of India, right, which represents the union. So similarly, somebody is needed to represent the states also, and that's why the Vice President as a counterbalance had been made as a chairperson of the Rajya Sabha, that is to represent the states. And hence there would be a parity as far as the post of the President and the Vice President is concerned. So here you'll be surprised to know, or you might be knowing also, that Vice President does not get any salary allowances, etc., being the Vice President of India, but Vice President has been designated as ex officio. Ex officio means by virtue of chairman of Rajya Sabha. So it's very simple to answer this question. However, you can also understand the demand of this question by understanding the role of Speaker of the Lok Sabha. So whatever the roles the Speaker performs for the Lok Sabha, most of them are performed by the Chairman of Rajya Sabha, except few. Like Speaker have the power to declare a bill or a money bill as money bill or not, or whenever there is a possibility of joint session, it would be presided over by the Speaker, not by the Chairman. But otherwise, here the Vice President acts as a Chairman, or we can say in that capacity as the presiding officer of the Council of State, or we can say Rajya Sabha. So his role as presiding officer, which will include definitely, take care of the proceedings of the House. So proceedings includes maintaining the quorum and the decorum in the house. So he will be or she would be entitled for the same. Then to take actions against the disqualification and qualifications of the members of the house. He or she is also entitled to take disciplinary action against the members. Okay. Then his role in acceptance of various motions, resolutions, passage of the bills, right, etc., or to conduct the legislative business, we can say. Then probably you can mention about the role as far as the day-to-day proceedings of the house is concerned. So proceedings, just like in Lok Sabha, what we have similar proceedings in the Rajya Sabha, right, and adjourning and so on. So this kind of role, I mean, basically you have to write the role of speaker only, but you have to use the name of the chairman and some miscellaneous roles like maintaining the privileges, etc., of the member as well as of the house. So like that we can say that role of vice president as a chairman is nothing but what? Acting in that particular capacity, he or she is mostly acting as what is the role prescribed by the speaker or prescribed for the speaker. For the Lok Sabha, similar role is prescribed for the chairman of Rajya Sabha. Right? Since this question is not for comparison, otherwise we could have compared the role of the speaker as well as the chairman both, but this question does not demand that particular thing because the question is very straightforward. You have to mention about the role of chairman of Rajya Sabha, that too as an ex officio, because the actual position of that person, so-called chairperson, is nothing but the vice president of India. So that's how we can say it's again one of the simple questions. Now let's move on to the next one. Here they are asking the question again, the keyword is discussed. So this time you people are quite lucky that you have got this keyword, and when the keyword is discussed, enjoy your day. If you know the content, it would be very easy for you all to actually write the answer, provided you know the facts. So here the role of they are asking for is National Commission for the backward class or backward classes in the wake of this or its transformation from a statutory body to a constitutional body. So this is also very important, especially when we discuss the Article 15 and 16, or we can relate this question from Article 15 and 16 background, that is fundamental rights. Plus we can take the help of Article 338 and then Article 340 as well. So these are the couple of constitutional positions, or we can say the provisions which are there in the constitution as far as origin of this particular body is concerned. However, mainly you can relate it with again the part 3 only because of the issue of reservation. So when we talk about what the question is asking, role of the National Commission for the backward classes, and especially you have to give it in the wake of transformation from being a statutory body to a constitutional body. That means here two aspects of the question is there. One, you have to write a bit of historical perspective, or we can say you have to write about evolutionary perspective of what? Of NCBC, that is National Commission for Backward Classes. Okay, that's the evolutionary perspective you'll be writing about, that what we have done, how this commission came into existence right from 1950s to, we can say, the recent one 2022, right? That is this part, transformation from a statutory body to a constitutional body. This could be the first part of the answer, and when we talk about the second part, then discuss the role. So the second part will have less emphasis, because when we talk about role, more or less the role of all the constitutional bodies, because once we confer a status of a constitutional body to any institution or organization, definitely its powers, functions and other authorities are increased. So let's try to see this question in this background. Now when we talk about this particular question, then here, as we know that if you want to give the passing reference, you can give the passing reference of Article 15 and 16, no doubt about it, in one or two statement, because the word limit is again very short. But how you are going to give the passing reference for these two? So I hope you remember all those clauses of 15 and 16. So basically both the articles have 6 clauses. Even 15 clause 1, 2, 3, 4, 5, 6 and 16 also have the same. Only in 4 we have 4A and 4. Now, both the articles talks about so-called no discrimination, and they are the part of right to equality. But you are not supposed to write so much in detail, just 15 and 16 as a passing reference. Why passing reference? Because here when we talk about this, then the origin, the evolutionary perspective of NCBC can be traced from. Now, when we talk about that no discrimination policy, right, there we have the so-called positive discrimination, or very popularly known as reservation policy. So in reservation policy, we know that, for SC and ST, it was from day one, and the proposal for SEBC has started popping up from First Amendment Act only, or the background for this was nothing but Champakam Dorai Rajan case. So from Champakam Dorai Rajan case, which was a landmark event as far as the providing the reservation is concerned, from there only the debate had been started as far as the reservation for the backward classes people are concerned, especially the other backward classes which are the part of SEBC. Because in SEBC we can say socially and educationally backward class people. So obviously these two classes are already covered. One is ST and other is ST. The remaining we can say the OBC, and collectively SC, ST, OBC can form, we can say, SEBC. So then the argument was on this backward class people, or so-called other backward. Other means other than the SC and ST. So for that, obviously, here the representation which is, or the reservation which is given, was proportional to their population, or we can say the adequate representation was there. But as far as the in SEBC the OBC population was concerned, that was not adequately measured. So for that, the beginning had started, by appointing the backward class commissions, we can say. But please remember, this was not the statutory body. This was the executive order created kind of thing. So two backward class commissions were there. First one was in early 50s, we can say, where it is also known as 𝐃𝐫𝐢𝐬𝐡𝐭𝐢 Commission. And second one, very popular, we know that in early or late 70s or early 80s, to be exact 79, this was known as BP Mandal Commission. Plus, please remember, this was neither statutory nor constitutional. This was, we can say, executive appointed these bodies to actually get the idea as far as the status or their composition in the overall population is concerned. Though much actions has not been taken on 𝐃𝐫𝐢𝐬𝐡𝐭𝐢 Commission, but here we can say BP Mandal Commission. So this was very popular, and finally they have recommended that more than 50%, or we can say close to 52% population comprises of the OBC. However, when it came to reservation, then probably the reservation cannot exceed the benchmark of 50%, that is Lakshman Rekha, as per the Supreme Court judgment in various cases like Balaji Mysore versus State of Mysore case and other such cases which we have discussed in detail in our regular polity classes. So you might be able to connect that also if you are from our institute. But 52% reservation cannot be given to them. Adequate means already we have 15 and 7.5%, so 22.5%. So the proposal has been to give the 27%. And when it was implemented during VP Singh Sahab government and then PV Narasimha Rao Sahab government, then the famous case, which is also known as Mandal case, or popularly known as Indira Sawhney case of 1992. From here you can say starts your answer. 7. Evolutionary part, the first instance you can mention about is nothing but the Mandal case. If you know the background, it's fine. If you don't know, then directly also you can go ahead with this Mandal case or so-called Indira Sawhney case. So there were multiple judgments in the Indira Sawhney case. One of the important verdict given by Supreme Court in this case was nothing but constitutionalization, we can say, or establishment of the Backward Class Commission. So following this verdict from the Supreme Court of India, the then government had decided to appoint this commission, and in 1993 the Backward Class Commission was appointed. But we know that it was appointed as a statutory body, right? However, the demands were there as far as statutory body should be made a constitutional body on the lines of National Commission for SC, National Commission for ST. So here the statutory body had got the transformation into a constitutional body, and we can say this was done very late by enacting another amendment in the Constitution, that is 102nd Amendment Act, which was done in 2018, and this was done or accorded the status of constitutional body. So here it was related to the subcategorization of the caste, the backward caste and the more backward caste kind of thing, which was the issue which was also raised in the state of Mysore versus Balaji or Balaji versus state of Mysore case, but there Supreme Court denied the subcategorization. Here in 2018 they have told for the subcategorization, and hence this body, so-called backward class commission, needs more empowerment, and that's how this body had been constituted or conferred the status of a constitutional body. That could be the first part of your answer. And second part, obviously you have to discuss about the rules about NCBC or National Commission for Backward Class. We can say that being a constitutional body, they will get the more power, or we can say they will get more authority, they will get more functional autonomy, plus they will get more investigating and other aspect, they will get the law and order enforcement kind of thing, etc., etc. So these could be the roles which you can depict upon, which you can discuss upon as far as the effect of being or making it a constitutional body is concerned. It will get more teeth, we can say, to implement the reforms or the proposals or recommend the government as far as the implementation of those policies are concerned, which are directed towards upliftment and empowerment of the backward class of people. However, we know that its recommendations are not binding on the government, so government is free to accept the recommendation or they may deny also. That was one of the, we can say, that is one of the critical or the weakness what these constitutional bodies have. Plus they will have the respected financial, we can say, autonomy also. They will get more powers and more functions also. This is the benefit of making any statutory body getting converted into a constitutional. Since the word limit is very small, very short, so we cannot include all the points, but at this point, at that point of time when you were writing the exam, whatever you had been in position to recall, I hope you might have mentioned those things. So following this, now let's move on to the another important question, and here if you see the question, again it is from the core areas only and the keyword is discussed. So that's a lovely thing we can say. Here they are asking essential condition for exercise of the legislative powers, right? Legislative powers of the governor. Discuss the legality of the repromulgation of the ordinances by the governor without placing them before the legislature. So this question, and now here the good thing, they have given the bigger word limit. That means it is going to help us in covering more points as far as this particular answer is concerned. So here again we can say divide the question in two parts. One, the essential condition for exercising the legislative power. So what could be the conditions and all those things? That could be the first part of the answer. And second, we have to write one of the sub-component of the legislative power, that is ordinance making power. So that would be the second aspect of the question in your main body. That too without placing them before the legislature. So let's try to see this question also. Again, a direct question from the part 6 of the Constitution, that is in the core areas only. And when we talk about the governor, as we know that here the governor, just like that of a president, because when we say president also exercises a lot of power like executive power, legislative power, judicial power, diplomatic power, military power, financial power, like that. So that power is conferred to the governor also in line with the president, because like the president is the constitutional head of the state, the governor is the constitutional head of the concerned state for which he or she is the governor. Here state matlab that country itself. So here governor also enjoys executive power, legislative power, judicial power and so on. But basically here the power we are talking about is nothing but the power of the governor with respect to this structure, so-called legislature, judiciary and executive. So since governor belongs to or is a part of executive, we know, right? and we know that we have a separation of power, but because of weak separation of power, we have some mechanism of checks and balances. So you can take this as a part of checks and balances also. And when we discuss the governor power as far as the legislative power is concerned, so what exactly the legislative power means? So we know that when we talk about the state legislature, so here you can say it has two options. Some states are unicameral in nature. When we say unicameral, that is one house only, popularly known as legislative assembly. But some states have the option of bicameral. That is, there we have the legislative council also. So irrespective of that, legislative assembly or council, because it varies from state to state, and now we have 22 states and 6 states kind of thing, right? The overall distribution, but this you are not supposed to write. This is just the background. But if you know this, it would be easy for you to handle the question. So actually we are talking about the powers of the governor with respect to these houses. So we know that whenever we talk about the state legislature, then state legislature can comprise, or it's comprised of 3 important entities. One is the legislative assembly, other is the legislative council, and third is the governor. So governor is a very much integral part of the state legislature, though he or she is not the member of legislative assembly or legislative council. But being the essential part of the legislature of the state, essential part means there are certain bills which needs the prior recommendation of the governor. There are certain the bills which need the assent of the governor. Okay. So then only the bills would be passed. So in that capacity, he or she enjoys a couple of legislative powers. So that legislative power may include the powers like, summoning the session as far as the prorogation of the sessions are concerned, dissolution of the assembly is concerned, okay, appointment of the speaker, deputy speaker, and these kind of functionaries, right? Or taking the action on qualification and disqualification, etc. of the members. So we can say these are a couple of power. Or President also addresses the assembly every year, the first session, the budget session, and then probably whenever the new election will take place for the assembly, because assembly is a temporary house. So it's just like the powers are coterminous with that of the president. And in that first part, you have to mention about these things only. However, when we talk about the ordinance making power, so though we study ordinance making power separately, but we know that this ordinance making power is nothing but broadly it is a part of legislative power only. Because what is the legislative power? Legislative power means power to legislate. That means power to make laws. And since this power to make laws, as I've told you, is conferred to what? It's conferred to legislature. That's not an executive power actually. It's a legislative power. But we know that legislature meets for a limited time. That is in budget session, in winter session, and in monsoon session. Or we can say monsoon session and then winter session. So overall we can see the legislature function may be for 100 or 120 days only in a year, right? But as we know, this law is nothing but directly or indirectly related with the society, which itself is dynamic in nature. And when we say it's dynamic, that means it's changing every now and then. And because of the changing nature of the society, we can need the law in certain urgent situation also, exceptional situation also. But at that point of time, if suppose the legislature is not functioning, then there must be someone who must be empowered to make the laws. And that special power is nothing but known as ordinance making power. So here ordinance will have the same effect as a law which is passed by the legislature. However, it is not the, we can say, special exclusive power given to the governor, but it's a special power given to the governor or a special power given to the President of India at the union level to meet those situational circumstances or exceptional circumstances in which if the legislature is not in session, then they must be empowered to make the laws. So like that you can give the background. So here governor of the state enjoys the power of making the ordinances. Ordinance making power is in Article 213 of the Constitution. It's just like reversal, Article 123 for the President and 213 for the governor. So here governor can promulgate the ordinances, especially when the legislature of the state is not in session. So that is what you have to mention, right? And if it is a bicameral legislature, then either house is not in session. Then also the governor can promulgate the ordinances. These ordinances will have the same effect, as I said, which is nothing but equivalent to the law passed by the state legislature. However, what we have to remember here is that ultimately the power to make the laws are lying with the legislature only. So it must be approved by the legislature, right, from 6 weeks within the assembly. So whenever the legislature assembles, that is comes into the session, then within 6 weeks, and the maximum period for which there is a gap, or there may be a gap between the two sessions of the assembly, could not be more than 6 months. So we can say in that capacity 6 months here and 6 weeks, like 1.5 months, so 7.5 months is what could be the validity of the ordinances, right? So this is the part which we have to mention. However, here what you can say that as far as before placing the legislature is concerned, or the part of or role of judiciary is concerned, as far as judicial review on the legislation, because this power can be misused. OMP, ordinance making power, can be misused, and you can give the passing reference of cases like Wadhwa case, right, or the Cooper case, right, which had actually, or SR Bomaik case also to a certain extent, which has actually sought to correct the irregularities or misappropriation or misutility of this particular ordinance making power. So in your answer you can mention about, or a passing reference you can give that yes, ordinance making power is allowed for the governor, no doubt about it, but that ordinance is not the same ordinance re-promulgated again and again, until there is no change in the statement or the verdict or the objective that ordinance is actually sought to achieve. And if it is re-promulgated just for the political mileage or a vote bank politics kind of thing, then it may be an unconstitutional thing, or it may be declared as invalid. So like that you can conclude your answer as well. So that is about the governor part. Now the another question we have is nothing but very much expected on the lines, critically examine you have to. The procedures through which the president of India as well as the president of France is elected. So here we know that this year only we have got our president election, and this year only we have got the elections in the French part also, and this is a part of, we can say, the topic from comparison of Indian constitution with the various other countries. So again a core area only which you may cover in polity, or you might have covered in your governance classes. So here simple question, right? One side we have to talk about the president of India, its election, and other side we have to talk about the president of France, right? So the basic points you all might be knowing only. As far as our president is concerned, then here we have the parliamentary form of government. So we have conferred the constitutional head position, or we can say a de jure head position, to our president, not the de facto, but the countries like US, France and all, they follow the presidential form of government where the president enjoys the real power, we can say, or de facto ruler of the state. So when we talk about the procedure, all the things you know about it, right? No need to repeat. In general classes you might have done what is the procedure, but here the difference part what we have to mention about is nothing but their elections. So when we talk about the elections, right, then we know that our presidential election is done through indirect mode of election. However, the election of the presidential form of government, president like US and France, that is also indirect only, but there is some degree of, what is that degree of difference? That is what you have to highlight. So when you take up this question, here what you have to do, mention about the indirect election, what we have for our president. So we know that there are two modes of election. One is the direct election and other is the indirect. For direct election, we follow the FPTP mechanism, that is first past the polls or first past the post, right? And for indirect election, we have to go for PR, that is proportional representation, single transferable vote and secret ballot. So here we have to constitute an electoral college, There are certain eligibility criteria for the members to become the member of electoral college. After that, we have to calculate the vote value of those members who are the part of electoral college. Then the person who is a winner has to secure the electoral quota as far as the winning candidate is concerned. They need to secure the electoral quota part, right? And then in case of disputes and all those things, the apex court of the country will decide about that dispute on the filing of an election petition. Similarly, when we talk about the President of France here, there also the election is, as I told you, indirect only, but here there is a difference, and that is nothing but the ballot voting system. So here they have a single ballot voting and double, that means twice. Now what this difference is? So this is the critical difference what we can say, which we can find between the election of the President of India and the election of the President of France. Now let's try to see what that difference is. So for that, we know that if we talk about the direct election, that is first past the post. The problem with this particular thing is, suppose there is a constituency in which 50 voters are there, and in that 50 voters, we can say there are 4 candidates who are there for contesting the elections, A, B, C, D. Each value is 1. So if A secures 17 vote, 11 vote, 13 vote, then 9 votes, this is, let's say, the outcome of the election. Then the person who has secured the maximum vote, that is first past the post, will be declared as winner. But if we carefully see the percentage, then he or she has scored 34% only, 22%, 26%, and 18%. Right, that means the winner had been in a position to secure only 34% vote. That implies what? There are 66% people who may or may not want the A to be elected candidate, but still A would be elected. This is the loophole what we have in direct election. But when we talk about indirect election, what happens? We all know. In indirect election, we go for the quota system, and for this part only, if we see the indirect part, then here at this point also A will not be declared as winner. Rather than a second round of counting will take place in our election if it is indirect, and there it will go on till the time A, B, C or D, any one of them secures more than 50% votes. So anybody who will get 26 votes, that person will be declared as winner. So since none of them had got the 26 votes, what will happen? The candidate who had secured the least vote will be eliminated, and the second choice of this voters of D will be getting converted into first choice for the other 3 candidates. So like that, this round of counting will go on, which we have discussed in detail in our regular classes also, till the time one is not securing the 26 votes. This is what happened in our case. But when we talk about the France, there also the same criteria is there. But the problem is what? Here in France, what will happen? Let's say there's 4 candidates are there, A, B, C, D, with the vote percentage of 17, 11, then 13 and 9. So here also nobody is a winner, no doubt about it. But there, this is the first ballot, that is the voting which has been done for the first time. In second ballot, what will happen? Since nobody is elected as a winner, then what will happen? Here the top 2 candidates who had secured the maximum votes, they will be picked up. So here we can say A had secured the maximum and C had secured the maximum. So here A 17% and B with, we can say, sorry, C with 13% is the what? Maximum. Rest all who had secured the lesser vote, they would be eliminated. And then what will happen? Again, there would be a second ballot. Then second ballot means not the counting, but second round of voting will take place. That means the whole election process would be repeated, which is not the case in our case. In our case, what happens? Only the second round of counting takes place. But in their case, the second round of voting takes place. So this becomes nullified. And again, this voting will take place. Anybody who is securing 26 seats will be declared as winner, because total 50 votes are there. So like that, it happens. You may say that if there is a tie and so on, so there is no probability of a tie because population is larger. We have taken a simple figure for the mathematical simplification or calculation. Otherwise, if there is a tie, neither the Constitution of India nor the Constitution of any other country in the world says that what will happen next. But suppose it happens, then the logical corollary may be there could be another election or a recall for the election, or a new election would take place. But abhi tak aisa hua nahi hai. It has not happened so far. So we are not sure pretty that what will happen at that time. So this is the, we can say, critical difference. As far as whether they are good or bad is concerned, so we can say to some extent they are good also, and to some extent they are bad also. So it could be good for a country like India because here conducting election itself, second round is going to be a costly affair. Plus we have a nominal head. That means we are not going to confer him the power which is equivalently given to the Prime Minister, which is a directly elected authority. But in France, the system is working, so it may be good for them, not for us, kind of thing. So that's how you can conclude your discussion, or we can say the debate part, right? So I guess that's all we have as far as the questions from the polity and governance segment is concerned. And most likely, see, there is not much effect as far as discussion of the questions is concerned after the exam had been done, because whatever you are supposed to write, you have already written in your answer sheets, and I'm sure you might have definitely put your best of the efforts to write the same. However, this discussion will definitely be helpful for the students who are going to appear maybe next year mains examination, so that they will get the basic idea how to approach those questions, which areas need to be focused more upon or to be focused more upon. You can see the questions are, all the questions which we have discussed are from the core only. If you have understanding of the core, it would be easy for, handling these questions. Being said so, last but not the least, what I would like to say that those who have wrote their mains examination, all the very best for their interview stage, the personality test, right? When the results are going to be announced, soon they will be called for their interview programs or interview test. So for that, all the best. And those who are willing to appear next year, definitely do read the current affairs, but that does not mean that you should ignore the core areas, because until unless the core areas are not covered properly, you will not be able to relate it with the current affairs part. All right. Thank you so much. Have a great day. Bye-bye.